Good day everyone, I'm Catherine Jana Maranto from BSc 3-5. Today I will discuss the alternative dispute resolution in the Philippines, the early neutral evaluation. Bago yun, ano nga ba yung alternative dispute resolution system? It is any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of the court or the officer of the government agency. A neutral third party participates to assist in the resolution of issues, which include arbitration, mediation, conciliation, early neutral evaluation, mini-trial, or any combination of thereof. Sinasabi dito na this is the process or the system used to resolve a conflict or problem between the two parties without the necessary intervention of a judge or without the presence of the judge. If in the ADR system, there is no intervention from a judge, so who is in charge to resolve the conflict between the two parties? The third person is responsible for assisting or helping in the resolution of the issue or the conflict, which could include the mediator, conciliator, arbitrator, or neutral evaluator, depending on the specific ADR method. Ngayon, ano naman ang Republic Act 9285? It is an act to institutionalize the use of alternative dispute resolution system in the Philippines and to establish the Office for Alternative Dispute Resolution and for other purposes. This act is also known as Alternative Dispute Resolution Act of 2004. It is hereby declared the policy of the state to actively promote party autonomy in the resolution of dispute or the freedom of the party to make their own arrangement to resolve their dispute. This act promotes the use of alternative dispute resolution methods such as mediation, arbitration, and conciliation to resolve conflict outside the court. Its goal to reduce court congestion and foster a culture of amicable settlement in the Philippines. The law also established the Office for Alternative Dispute Resolution, or the OADR. The next naman is the Office of Alternative Dispute Resolution is responsible for formulating training standards, certifying practitioners, and promoting an enlightened society that empowers parties to resolve the dispute fairly. Then, nandito naman yung mga power and function of the Office for Alternative Dispute Resolution. First is to formulate standard for the training of the ADR practitioners and service providers. Second is to certify that such ADR practitioners and ADR service providers have undergone the professional training provided by the office. Third is to coordinate the development, implementation, monitoring, and evaluation of the government ADR programs. Fourth, to charge fees for their services. And the last is to perform such acts as may be necessary to carry into effect the provision of this act. So today I will discuss only the one of ADR method, which is the early neutral evaluation. The early neutral evaluation, it is an ADR process wherein the parties and their lawyers are brought together early in the pre-trial phase to present summaries of their cases and receive a non-binding assessment by an experienced neutral person with expertise in the subject in the substance of the dispute. It means there's no trial yet, or even in the pre-trial stage, a third person is already involved to assist or help in the dispute. This person presents a non-binding assessment, which means it depends on the parties whether they will follow or accept the agreement from the other parties. So now we proceed to the process of the early neutral evaluation. In the first stage, the appointment of the evaluator. The parties ensure that the evaluator appointed has the special knowledge and expertise in the subject matter and fairness, impartiality, and skill in evaluating facts and circumstances. This makes the process of evaluation more effective and reliable. Both parties can choose one or more evaluator at their discretion. In the first step, it is selecting a neutral evaluator. The evaluator plays a crucial role, so it is essential that the parties choose someone with relevant expertise in the subject matter of the dispute. The evaluator should be fair, impartial, and capable of analyzing complex facts and legal issues. Parties have the flexibility to appoint one or more evaluators depends on their needs. The next stage is the preparation of neutral evaluation. Before the proceeding, the parties are required to submit a written statement stating the facts and issues from their point of view. This enables the parties to understand the perspective of both parties. Also, the parties decide the date, time, and the venue of the evaluation. In this stage, before the evaluation process begins, both parties must submit written statement. This statement provides an overview of the facts and issues. The written submission helps the evaluator to understand the dispute and prepare for the evaluation. The parties also agree on the date, time, and the location of the evaluation. And the third stage is the evaluator's opening statement. And the proceeding begins with the evaluator's opening statement, where the evaluator explains the roles as the neutral third party and state the rules for the proceeding. After the start of proceeding, the evaluator provides an opening statement where they explain their roles as a neutral third party and rules of the process. This opening ensures that the parties understand the purpose of the early neutral evaluation, and also the evaluator describes the stage of the proceeding to ensure the transparency and the clarity on how the evaluation will be proceeded. In the fourth stage is the parties' presentation. Both parties present their perspectives on the case, the issues that are important pertaining to the case, and the outcome they are seeking from the proceeding. After the opening statement, both parties try to present their perspective or understanding on the case and highlighting the key issues and what they want as an outcome. This step is very important because it makes the parties aware of the perspective of the other parties. It also clears up any sort of misunderstanding between the disputant, while also allowing the evaluator to identify the key issue. The last stage is the evaluator's opinion. The final step of the proceeding is the opinion of the evaluator. The neutral third party will provide his opinion on every issue of the dispute, and then suggest possible points on which parties may negotiate and compromise. The evaluator also mentioned the possible outcome of litigation if the parties decide to move to the court. At the end of the proceeding, the evaluator gives a non-binding opinion on the case and suggests possible negotiation points and the outcome if the dispute moves to the court. This opinion can guide further negotiations, but parties can choose to accept it or to pursue the other legal options. Now we'll discuss the advantage and the disadvantage of the early neutral evaluation. The first advantage, it can be short process and save legal expenses. Early neutral evaluation help the parties to resolve the dispute quickly, which save time and money on the legal expenses. And by resolving issues early, they can avoid the lengthy court battles. The second advantage is the evaluator will give a realistic assessment of prospects of success of each other. Which parties better understand their legal position, they may be more prepared to come to the table and negotiate. Third advantage is a wide application to many types of disputes. It can be used for different types of disputes such as a business, civil, or labor issues. This makes it a useful tool for various situations, allowing parties to find solutions that fit their specific needs. Then we proceed naman sa disadvantage of early neutral evaluation. Depending on the E&E agreement drawn up by the parties, the process can potentially become lengthy. This could prove expensive as ultimately the evaluator decision is not binding. The second disadvantage is the losing side may not accept the evaluator's decision and therefore decide to proceed with litigation. The third disadvantage is the narrow application. The E&E may not address all aspects of complex dispute, leaving some issues unresolved and requiring further litigation or formal trial.